please the court, counsel?
My name is David Cmelik. I represent Jesus Angel Ramirez, who comes before this court by way of Blackhawk County jury verdicts of guilty on PCS with intent greater than 5 grams and being a second offender, as well as related drug tax stamp violation. The Honorable George Stigler presided over the suppression hearing, the jury trial, and the sentencing. And with jury verdicts of guilty, Judge Stigler sentenced the defendant to 50 years on count 1 and 5 years on count 2, consecutive to one another, and consecutive to an unrelated parole matter. As a point of reference, the defendant has been sentenced to a total of 145 years, and his tentative discharge date will not be until 4/10 of 2071. I'd like to focus today on whether this court should waive both Iowa Chapter 808 as well as Article 1, Section 8, when a federal magistrate issues an anticipatory warrant executed largely by Waterloo Police Department officers in the mere presence of federal actors. So the first question on the table is whether this is really a constitutional issue or whether it is merely a statutory one. It is both for the following reasons. First, Chapter 808 codifies and contextualizes constitutional rights that do not have any history in the common law. As the Gillespie decision notes, there was no right to issue a warrant established in the common law, and that was the criticism leveled at the lower court when it otherwise stated that neither 808.3 nor 808.4 negated the common law of search warrants. Second, the historical context of probable cause derives from a rich history of state constitutions themselves, as this court noted in Ochoa and Baldwin. Consider this court's holdings revisiting the history of John Adams' Massachusetts search and seizure provision, which read, "All warrants therefore are contrary to this right if the cause or foundation of them be not previously supported."
U.S. Supreme Court in Gibbs said unanimously that under the Fourth Amendment, there's nothing wrong with anticipatory warrants.
That's
right?
correct, Your Honor.
So I understand that we have an interpretation in Gillespie of the statute that says they're not statutorily authorized in Iowa, but where does the constitutional problem come?
Justice Scalia's opinion holding conflates probable cause with the fruits of a warrant because the fruits are predicted, but the probable cause must appear before the warrant is issued. Interestingly, Justice Scalia's typical historical analysis and textualism doesn't appear in that decision and does not refer back to things like John Adams' Massachusetts provision or James Madison's first draft and proposal for the Fourth Amendment. And this court and this state has a richer tradition of protecting citizens' rights than does the Fourth Amendment. In addition, the Grubbs decision is the type of jurisprudence of the United States Supreme Court in the search and seizure arena that has been characterized by scholars, as this court in short pointed out, not merely complex and contradictory, but often perverse. So the state expends a fair amount of energy urging this court to reject a choice of law analysis and to choose an exclusionary rule analysis to figure out exactly how to treat federal actors in the state court system and whether or not the state constitution will apply to them. And I urge this court to look at the Torres decision that's actually cited in the government's briefs. The government suggests instead a balancing test, but the Torres decision rejects or at least incorporates a balancing test in favor of due consideration to the Hawaii state constitution in that case. The Torres case was about a guard shack at Pearl Harbor Naval Base, and someone who had a all-points bullet now was coming into the base, and the guard shack police officer recognized that person to have an all-points bullet now for them. When this person was going to drive on to the base, they would be in exclusive federal jurisdiction. They would be in on a military base. So when this person did that voluntarily, the guard shack officer reached in, grabbed his keys out, and seized the defendant, seized the vehicle, and under the authority of the commandant, searched the vehicle and found a .38 revolver with some spent cartridge casings in it. Those cartridge casings were later used in a second-degree murder trial in the state of Hawaii, and the state Supreme Court went through the analysis of whether or not the state constitution should apply and found that the use of that evidence wouldn't violate the Hawaii Constitution. So what we can do here is either a lockstep approach with the federal government with a kind of contorted analysis of whether or not these particular people, whether we are going to waive Article 1, Section 8 or Section 8.
What about, instead of a lockstep approach, just kind of analyze the interests here? And it strikes me, I understand you dispute this, but if we come to the conclusion that this was a valid federal warrant issued for what was at the time a federal operation, what interest are we vindicating by not recognizing the warrant? It would be analogous to we recognized prior federal convictions, of course. Sometimes they didn't comport procedurally with things that we require in Iowa. What is the underlying interest that we're trying to vindicate here by not recognizing the fruits of this particular federal? Assume it plays out that those are the facts.
Yes, sir. The interest is adherence to Article 1, Section 8, and ensuring that state actors are not violating it. In this particular case, state actors comprise the bulk of what was going on in the execution of the warrant. In fact, in the investigation as well, Jason Paul Feeker, who is a member of the Waterloo Police Department, and Special Agent Moore from the Homeland Security Department, they communicated about the aliases involved and the apartment for Jose Robles, a.k.a. Jesus Ramirez.
Be making the same argument today if there had been no state law enforcement involved?
I would be making an argument that a categorical prohibition on the use of this evidence in this court pursuant to Article 1, Section 8, that it would be categorically prohibited. But I don't think we need to reach a categorical prohibition in order to reverse and remand for a hearing on the merits and for a new trial in this particular case.
Unless we say that the Iowa Constitution and the United States Constitution are, in this instance, to be construed similarly. I mean, I know we have Gillespie, but Gillespie, I guess, is and correct me if I'm wrong, Gillespie is a statutory case, is it not? That's
correct, but that statute would not exist but for a constitutional section, Article 1, Section 8.
This way, what are the constitutional policy concerns that you might have with respect to anticipatory warrants, such as one in this case?
That if there's no probable cause to begin with, that the probable cause would be, the decision whether or not probable cause is met is really placed in the hands of the state and or federal actors. That the idea that a neutral and detached magistrate isn't making the decision about whether or not
But there's an objective fact that has to be met. I mean, when I was in practice too, I remember I had a case that I handled where there was an anticipatory warrant, and there was always an objective criterion that has to be met. It isn't the judgment of people on the scene. Now, I understand you dispute that, but if we construe the warrant to say that once the delivery is made, then the search may proceed, you're not conferring discretion, are you?
Well, in this particular case, this is a case in point of why anticipatory warrants don't work. It's because these officers had more conditions than just delivery. They installed a transmitting device inside the box, and in paragraph 6 and 8 of the warrant application, told the Honorable John S. Scholes that they were going to wait until the box was opened until they executed the warrant.
That's what they said in the application, but then the actual warrant itself didn't say that, and that's really what controls, isn't it? Or at least that's what the court below said.
Under Grubbs, they don't. The neutral and detached magistrate doesn't have to put every condition with particularity into the actual warrant, but it's clear from the record that these officers, and from testimony during trial, that these officers believed that they were going to wait until the package was opened before they broke into the apartment, and that did not happen. When they went into the apartment, they found an unopened box, and so the conditions were not met, if that answers your question, Your Honor.
What do you make of the Davis case?
Under Davis, I'm sorry, Your Honor.
Davis, that's the case where the Missouri officers executed a search warrant that arguably under Iowa law might have been invalid because Missouri embraces a good faith exception to the exclusionary rule. Iowa does not. And as I quickly read Davis, it seemed to suggest, it held that we were going to follow Missouri law rather than Iowa law. So correct me if my interpretation is wrong, but of what relevance does that have for us? The state cites it at least.
Absolutely, Your Honor. It's actually not quite parallel to this situation because of the Iowa and the Missouri cases. Those are two separate, that's a choice of law case, where the forum state is Iowa, and the situs of the search warrant, and the prosecutor who sought the search warrant in the Davis case were all from Missouri. There was an affidavit or a statement attached from a law enforcement officer across the border because, of course, the allegation was that the vandalism occurred across the border. So, but in that particular case, it's really a choice of law case as between Missouri and Iowa law.
Isn't Davis, I mean, we could have said that we're not going to, I mean, just as we have the option to say so here, we could have said in Davis that we don't recognize the good faith exception. That was a bad search under Missouri law. It was a bad search under Iowa law. We're not going to allow the fruits of that search in our courts. It seems to me that Davis is the harder case than this one because the search was bad. Here you had a search that was a good search under the aegis of the federal courts and under the aegis of the federal officials that led it. Now, I understand you dispute that, but if we find that this was truly a federal search and not some effort to circumvent things, doesn't that make this an easier case than Davis?
I don't see it as an easier case because of the concurrent jurisdiction, and because we have law enforcement officers. We've married these investigations, these agencies together in the Tri-County Drug Task Force, and it's Waterloo police officers who are conducting the execution of the warrant, and they were involved even before Special Agent Moore sought the warrant. And part of the information that Waterloo police officers had provided to the Homeland Security Special Agent wound up in the search warrant application. The state in this case and the record reflect that the choice between these two fora is a common one, that it happens quite frequently that the United States Attorney's Office will refrain from prosecution and let the state take the lead, let the county prosecutor take the lead. And if that's the case, going back to the policy reasons for why this is a more complicated and a more important case, is that will lead to lesser protections under Article 1, Section 8 on a more frequent basis than this sort of occasional occurrence that happened in State v. Davis. If that answers your question, Your Honor. And I believe I am over time.
I think you have a minute left.
Oh, very good, Your Honor. So even the state's appeals to other cases that involve sort of a buyer's approach to this, where we look at who's involved, whether it's the federal or the state actors, whether it's the federal agents or the state agents, even the state's appeals to, for example, Cmelik in New Jersey, Pena in Texas, and Cryer in Massachusetts, the critical question is the relationship vel non as between the state and federal agents. The Cmelik used the word alloyed to describe such a relationship, and stating that if the investigation is any way alloyed, the state constitution would apply to the fruits of the investigation. Webster's dictionary defines alloy as a mixture of a substance, two or more metals, or a non-metal, intimately united. And I think that's really what's happening in the case at bar.
If this is just if it's just a total federal investigation, how would the purpose of the suppression rule be served if we kept it out of state court?
The reason that we're here today is because of a choice that the Northern District of Iowa and that the Blackhawk County Attorney's Office made. The choice of forum was 100% the government's choice. They understand the rules in state court, and this is the perfect example to this is the good faith exception. If there's a good faith exception case, they know that they're going to try to choose the forum that helps that situation better and not come into state court. If we follow the state's rule or rationale in this case, if there is a federal magistrate who issues a writ of assistance, for example, that they can stop anybody who has a parole contract that indicates they have consented to a search, that would obviate an entire line of cases of this court. If there was no such magistrate, if a federal officer engaged in this kind of conduct because he or she believed that there was that it was okay under federal law to search somebody without suspicion if they were a parolee, then that would also obviate that same line of cases.
And I get that. If we review the record and we conclude this is an effort to sort of circumvent our law, then I'm with you. But what if it isn't?
Even if it isn't, the deterrent force of the decision will prevent any violations of the Constitution or any type of misconduct in the future. What the state's rationale in this particular case is essentially a balance between the good faith of the officer and the value of the evidence. But that is just a return to the idea of the good faith exception that was rejected in Klein. So it's not really about the bad faith or the good faith of the officer. It's about whether or not this court will waive prohibitions that have nothing to do with whether or not the officer had good intentions. An officer can have good intentions and break into somebody's garage and say, "Oh, I see some methamphetamine," and so they have good intentions because they want to catch the bad guy, but they can still run afoul of this state's Constitution, which provides greater protection than the federal Constitution, if that answers your question, Your Honor. So,
Okay, you may sum up.
thank you, Your Honor. The idea here is that this will open the floodgates and will give another option to law enforcement and federal and state prosecutors that will basically nullify this state's entire line of cases that say that we have greater protections under Article 1, Section 8 than the federal version. Thank you, Your Honor.
Thank you as well. Ms. Reinkoester?
Thank you, Your Honor. May it please the court, counsel. This situation is quite rare, actually, and I think any decision that is made today isn't going to open the floodgates of any particular type of use of evidence. As you can see from the cases that I cite in my brief, I had to do a state survey to find enough cases to anticipate this issue. But I think maybe the best case to look to for your decision today is the State v. Davis case. I think it's quite analogous to the situation here. The only difference being that we have a state as the separate jurisdiction rather than the federal government. I mean, in that case, we have more participation by state officers than we do in this case. In Davis, we had it seemed like it was an investigation that was headed by Iowa officers, and the Iowa officers enlisted the help of a Missouri prosecutor in order to obtain a Missouri search warrant. Iowa officers also executed the warrant on the Missouri property and then collected the evidence, was tested in Iowa, and it was used in an Iowa state prosecution. And in Davis, this court found that we didn't, because the warrant wasn't, even though the warrant was defective under Missouri law, because the Missouri state courts would apply the good faith exception, that Iowa had no greater interest in protecting Missouri statutes than Missouri did, and so we agreed to that applying the good faith exception and allowing the evidence in that case would be permitted.
But when you look at the Davis case, Iowa officers had no jurisdiction over anything in Missouri. The difference here is that both the federal officers and the state officers had jurisdiction over Iowa. And I think that's significant, or don't you see that significant?
I don't think it's significant in this particular case because even though there's concurrent jurisdiction between the federal and the state officers in this case, all indications in the record is that this was a federal investigation that was being headed by federal officials that was intended for a federal prosecution. The federal officials enlisted the help of the state officers in participating in the execution of the
Why
warrant.
shouldn't we leave it to a federal prosecution and say that the state can't use the evidence in state court if that's what the intent was, that was the purpose, and that way we wouldn't undermine our own constitutional or statutory provisions?
We could leave it to a federal prosecution under those circumstances, but we don't necessarily have to. And that's sort of the question that we're here to answer, which is when evidence is lawfully obtained in a federal court or federal jurisdiction or another state jurisdiction, if that evidence couldn't have been obtained by Iowa actors in Iowa, should we allow prosecutors to use it in an Iowa state court?
Yeah, but every case you cite, and it's on page 24 of your brief, it was always obtained in another jurisdiction where it was legal in that jurisdiction. You don't have a case where it was a state and that I could find, a state and federal actor. And it appears to me that there's some traction to the argument that if the federal constitution allows greater searches than our state constitution, why wouldn't state police or state county attorneys go to the federal government and say, will you get a search warrant for this because we can't do it under Iowa law because we don't have this exception or we don't have that exception, as we start narrowing the searches under the Iowa Constitution, and then give it to the state actors? I mean, that seems to be a big problem to me.
So the first thing is that there's a case from Massachusetts called Commonwealth v. Gonzalez that anticipates the actions of federal actors within the state of Massachusetts. It's a little different, a lot different, I actually think, from this particular case because it has to do with the construction of a joint jurisdictional statute in Massachusetts, but that does speak to some of these same broader issues. In terms of what you're talking about of using sort of the federal jurisdiction to sort of get around the Iowa rules, the state doesn't argue that that's not permitted. If there's collusion or bad faith on the actors
But we don't want to get into that kind of inquiry. We don't want to check whether there's good faith or bad faith ordinarily. I don't think. Why not just take the approach Franklin and Klein, which emphasized the strength of the Iowa Constitution and the integrity of our courts, and just say, look, in a state court, for a state prosecution offered by state prosecutors and against a state defendant on state charges, we're going to insist on state constitutional search and seizure requirements. Bright line rule, easy to enforce, no problem. Don't have end runs.
Well, that would require you to find that this has violated a constitutional principle.
I agree with that. I agree with that too.
And the state does not believe it does.
I understand, but just take my hypothetical though. It just seems to me that's a much clearer approach than kind of looking around for good faith and who did what when, and you'd have your chronology chart here, and we'd be soothsaying into somebody's brain. I mean, I really don't care to do that. I don't think.
No, I understand that the idea of having a bright line rule is very appealing. But I think as the cases that are outlined in my brief show, that these situations arise in a wide variety of circumstances to which a bright line rule really isn't applicable. And I think that, one of the cases that I find to be probably more restrictive, it was a case that was cited by the defendant, which is State v. Torres from Hawaii. And even then, even when they consider their own Hawaiian constitutional principles, they do not automatically exclude the evidence. They still engage in this exclusionary rule analysis to determine whether they should allow the use of the evidence. So I have not encountered any of the states that have considered these issues that any of them have crafted a bright line rule in order to make that determination. It has to be, just by necessity, a case-by-case
We
determination.
have another case pending in front of us right now where the issue is whether something was a private search or a state search, and there really isn't a bright line rule for that either. I mean, it's just
Is that
like,
my case too? I think it might be.
got that. But on the other hand, in this particular case, I mean, the federal statute of limitations has not run. The feds could prosecute Mr. Ramirez. I mean, that's a possibility, right?
I'm trying to remember how long ago this initial arrest was. Was it
2014, I
2014?
thought.
If it's 2014, then no. And it could, we could, allow the federal government to take this case. But the question is, should we require that in these circumstances? And I don't think that anything about this particular case would require a finding that the federal government must be the ones who prosecute this case simply because they're the ones who headed the investigation. We have.
Do you know why they declined to prosecute?
I don't, Your Honor.
And why should we interpret the Iowa Constitution to allow anticipatory warrants, which by definition, you're going to have a neutral magistrate approve it, and by definition, the contraband is going to be at the place at the time the search is executed.
So constitutionally, both under the Iowa Constitution and under the federal Constitution, there's only 3 requirements for a warrant: that it be supported by probable cause, that it be supported by oath or affirmation, and that it be specific about the person or place to be searched or seized. In United States v. Grubbs, the federal case from the United States Supreme Court, as well as every single state constitutional case that I was able to find, there's not been one jurisdiction to find that anticipatory warrants violate the state constitution. And that's because anticipatory warrants are supported by probable cause. It's not that the probable cause will exist in the future. The probable cause exists when the warrant is issued. So in that terms, it doesn't violate our constitutional principles because we have all 3 things in this particular warrant. It's simply that we have, or this court has determined in Gillespie to interpret our statutes in a more strict manner in terms of the procedural requirements necessary to obtain the search warrant.
Was Gillespie wrongly decided?
I don't think so. Well, it's hard to say, and that's not an argument that I make in my brief at this particular junction. I think that anticipatory search warrants, it appears, sort of fell into favor in the early 90s, and that Gillespie might have been on the cusp of cases determining whether anticipatory search warrants were permitted by statute or by constitutional mandate. So in terms of looking at that case, there have been about 30 state courts that have ruled that anticipatory warrants, whether they violate statute or constitutional principles. And Iowa was only one of 5 states that ever found that anticipatory warrants violate a statutory principle, and only a statutory principle. No one has ever, as I said, found
To
it
adopt a bright line rule that we won't recognize in our courts any search that would not be valid if conducted by Iowa law enforcement, wouldn't that require us to overrule Davis?
Would you say that again, Your Honor, please? Sorry.
Yeah, I'm sorry. Wouldn't we have to overrule Davis if we wanted to adopt a bright line rule that in our courts we're not going to recognize any search that would not be valid if conducted by Iowa law enforcement under the standards that we've imposed on our own state officials?
I'm not sure. That isn't an issue I contemplated. Maybe. I think this is a slightly, it would be a slightly different situation in terms of drawing those two rules, but
The suggestion is there's a difference, and I'm asking for your opinion now. The suggestion from your opposition is there's a difference between federalism and concurrent jurisdiction and the situation with two states, and I think Justice Wiggins' question was along that line too. Does that matter at all?
I really don't think it does. Mostly because we're still talking about operators who work in their own jurisdictions under the rules of their own jurisdictions. You know, I think especially in this case, the record doesn't show that the law enforcement officers were exercising concurrent jurisdiction. You know, it appears, if anything, that the state officers were working only at the direction and specifications of the federal officers, and so they weren't even exercising necessarily their own jurisdiction in the case. They were simply aiding the execution of a federal search warrant. And I just do want to address defendant's contention that the state actors were the majority actors in this case. That also does not appear to be the case. If anything, I sort of seen it's sort of 50-50. And in terms of who's running the operation, I think the record clearly shows that the federal agents were running the operation and that the state actors were not at all involved in the search and inventory of the apartment that was entered.
Davis,
In terms of executing the warrant, as I recall the briefs, it was a state actor that broke the door down, and it was a state actor that actually seized the box.
I believe that the entry team was state actors, but that no state actor seized the box. I don't recall that from the record. I recall that they noticed the box and where it was because it was close to the entrance of where they breached the door, but they otherwise stepped out and the federal team entered to do the search.
Davis,
But they're executing the search warrant pursuant to a valid anticipatory warrant that's allowed under the federal statute. So they're entering under the authority of a valid warrant. So what's wrong with that?
I don't
I don't
think
really care if they're state actors or not. If they're operating under a valid federal search warrant, isn't that good enough?
I would agree with you that that's enough. The reason I draw that distinction is that some of the cases that I rely on do inquire about whether or not the involvement, the joint operation between the federal actors and the state actors, and the crux of that inquiry is whether the federal actors could be considered under color of state law, not whether the state actors could have been considered working under a color of federal law. So that's why I draw that distinction, because there are a number of the cases in this realm that really do place emphasis on the role of the state actors in participating with the collection of the evidence.
you talked about the Hawaii case, but the Davis case doesn't have that weighing. It creates a bright line rule that if your warrant is good in another jurisdiction, we're not going to suppress it here. I mean, what's wrong with the bright line rule that when you have concurrent jurisdiction, the warrant is no good?
I don't believe that. The way I read Davis, I should say, is that I don't see that it established a bright line rule. I see that it used a conflicts of law analysis to weigh the varying interests between Missouri and Iowa and made a determination based on the circumstances of that case that we would apply the good faith exception to the exclusionary rule in Missouri. So I don't think that the way I read Davis it doesn't stand for the proposition of a bright line rule of always allowing evidence from another jurisdiction into an Iowa court. Thank you very much.
Thank you.
The state would ask that you affirm the conviction of the defendant.
Thank you as well, counsel. Rebuttal?
I'd like to, at least as a preliminary matter, dispel this notion that federal actors participated or at least took the lead in the execution of the search warrant. It's very clear from the record that Jason Paul Feeker gave the order to ram the door. Michael Gersh rammed the door. Jason Paul Feeker grabbed the box on the bed. So these are state actors. These are Waterloo police
Can you
officers.
give me a citation on that in the transcript?
I'm sorry, Your Honor, not at the moment. I cannot.
Was there any evidence that that the law enforcement in this case went to the federal magistrate or used the federal magistrate for the purpose of avoiding state constitutional protections?
There's nothing in the record to that effect. However, when Tyler Moore, Special Agent to Homeland Security, wrote his application for the search warrant, he had already received information from state law enforcement. And the information that he had received apparently came from an Iowa database for aliases. He called it the SHIELD database, or I believe it was Jason Feeker called it the SHIELD database. And nothing about Jason Paul Feeker nor the SHIELD database, as I understand it, after reviewing the warrant application, appears in the application. If you want to bolster your probable cause, if you want to show that you have information from supporting agencies and officers, it strikes me that you would say, in the warrant application, I have contacted the Waterloo Police Department and the Tri-County Drug Task Force, and they have informed me through their independent records that this person and the addressed party are one and the same. He could have also said that even though our package does not have the number, apartment number 2 on the address, that I obtained that information from Waterloo Police Department, an independent Iowa state agency. My understanding and my recollection and review of the warrant application materials is that's nowhere in the application.
What if the anticipatory search warrant was obtained in Missouri and it was executed here? Would you have the same problem, or would this Davis get in the way of your argument?
I don't think Davis gets in the way of the argument because we have a situs here, just like we have a situs in Waterloo. And when you talk about the choice of law analysis as between the situs and the forum state, what we're really talking about is the forum and the situs being the same here. And so when you have that difficulty, we should apply Iowa's laws from the middle of the Mississippi Channel to the eastern border of the Missouri River, which is, I believe, how it is crafted in the Iowa Constitution.
Counsel, why shouldn't we follow the majority of other state courts and the unanimous U.S. Supreme Court decision and hold that under the Iowa Constitution, anticipatory warrants are permitted?
Well, first, as a matter of public policy, the legislature has already deemed that, and this court in Gillespie has already decided that anticipatory warrants lack probable cause, and so there is persuasion on the other side as well. Understanding that this court can look to other states when determining how to independently review Iowa's Constitution, I believe that those other state decisions are unpersuasive, Your Honor.
How do you get around the problem that obviously this started as a federal investigation, and it was in fact a federal operation, whether it was executed by Tri-County Drug Task Force or whoever, state actors in this matter, with the whole understanding that it was going to be a federal prosecution. And then, of course, the feds changed their mind and they decide not to prosecute. I'm struggling with the idea that evidence obtained pursuant to a valid search warrant under the federal statute and under federal law can now somehow be converted so it's no longer appropriate under Iowa law, because we've now determined that we're now going to prosecute it on a statewide basis instead, or a state basis, as opposed to a federal one. Do you see where my problem is with that? Is that we can go all the way along. These decisions as to prosecution are out of everyone else's hands other than the U.S. Attorney's Office, whether they want to prosecute it. But it was clearly a federal investigation.
Well, Your Honor, if I may, it was a federal investigation until it wasn't. And like I tell my clients, sometimes Mayberry is Mayberry until it isn't, until they're treated unfairly by law enforcement. In this,
we're not saying they're being treated unfairly by law enforcement here. We had all the elements of a valid warrant was here under federal law to obtain this evidence, and so that was the chief's question, I believe. Is there some evidence to show that we're trying to violate this person's rights somehow? No, there's nothing here to show that.
Your Honor, as I understand it, it is this court's prerogative and right to review search warrants of a federal magistrate or of a state court magistrate. If a state court magistrate had issued this warrant, the state has already conceded it would be illegal. So the only difference...
Can I ask one more question? You know, I guess the other way to look at this then, every time you do a federal search pursuant to a federal warrant like this, if you're not sure whether or not you're going to prosecute it federally or state, then what you really need to do, once you've gone in, you've seized that property validly, then you simply need to, again, you talk about a silver platter, then you simply need to say, look, Waterloo Police, you need to go get another warrant, and now you have probable cause. We've got all the goods right here, sitting here. Now you go get the warrant, you have probable cause, then it's going to be admissible in court, correct?
I don't think so, Your Honor. I don't think that duplication is necessary. What needs to happen, I believe, is that if the law enforcement officers and the respective prosecutors, whether they be in the Northern District or in Black Hawk County, if they can foresee or believe that they will make a choice between the two fora, then they should instruct their officers to comply with both federal and state constitutional law. And if they do that, they won't run afoul of federal law because the Iowa Constitution provides a stricter standard. Thank you, Your Honor.
Thank you as well, Mr. Cmelik. The case of State versus Ramirez then is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.